What started on 23rd of March 2023 in Surat has come a full circle on 4th of August 2023. The Supreme Court of India has stayed the conviction and 2-year jail term imposed upon Rahul Gandhi by the Surat Court. Basis this judgment of the District Court of Surat on 24th of March 2023, the Lok Sabha Speaker Om Birla disqualified Rahul Gandhi from his membership of the Lok Sabha from Kerala's Wayanad constituency. The lightning speed with which the Lok Sabha acted upon the CJM judgment to disqualify Rahul Gandhi not just bedazzled the nation but even took politicians of all hues by surprise that the Lok Sabha Secretariat would act with such lightning speed. The state, if desired, can act, provided there is a political motive and intention to do so. Justified or not, the game of politics has acquired a brashness of its own in the past 10 odd years. And then, without losing time, Mr. Gandhi was asked to vacate his official home as well. The motive was very clear, intent focused. Gandhi's watch out. You shall not breathe easy even for a second. Amidst the hotly contested Adani saga during the budget session, Rahul Gandhi had attacked the Prime Minister, Modi government policies and government's core, which is its nationalistic image, by referring to Chinese transgression within Indian territories in Ladakh. 24th March onwards, no such opportunity should be given to Rahul Gandhi unless the highest court intervenes. But by then the message would have impressed upon the court voters of BJP that we do not allow anyone messing with us. The Congress and Rahul Gandhi also tried to drag the issue as much as possible. This helped Congress play the victim card, which till now has been effectively and wisely played by none other than the Prime Minister of India, Prime Minister Narendra Modi, on several occasions. It was clear from the start that the revision petition in Surat Court or the plea in the Gujarat High Court would not offer any relief to Rahul Gandhi. Only the Supreme Court would offer a relief to Rahul Gandhi. Now this in itself presents the saddest side of Indian judicial system. Such is the grip of a state, and here I mean the state government or the central government, on several high courts and district courts of the country, that justice is often compromised. One doesn't have to judge this via Rahul Gandhi's case alone or by itself. One could see this during Riya Chakravarti's case, Shah Rukh Khan's son's case, Hathras gang rape case, and recently Manipur High Court order on reservation of Meiteis, and so on. The high courts and lower courts virtually end up acting like extension of the ruling party. Let's begin with Surat's Chief Judicial Magistrate H Varma's judgment on 23rd of March 2023. Convicting Rahul Gandhi under section 499 and 500 of IPC for defamation, he observed, if the accused was given a lesser sentence, it would send a wrong message to the public and the purpose of defamation law would not be fulfilled. Rahul Gandhi could have limited his speech to Prime Minister Narendra Modi, Nirav Modi, Vijay Mallya, Mehul Choksi or Anil Ambani, but he intentionally made a statement that hurt individuals carrying Modi's surname. How could the Prime Minister be insulted? That's why Rahul Gandhi merited the maximum sentence, which happened to be 2 years, and which also happened to be the minimum punishment required to disqualify an elected MP or an MLA from the post of his occupation vis-a-vis the 2013 Lily Thomas versus Union of India judgment of the Supreme Court. Doesn't this strike a chord to you? Chief Judicial Magistrate Varma further continued to fortify his judgment by alluding to 2018 ruling of the Supreme Court, where the court had asked Rahul Gandhi from making or refraining from making statements like Chaukidar Chor hai. The CJM had said, even though the accused was advised by the Supreme Court to remain alert, there doesn't seem to be any change in his conduct. And what had Rahul Gandhi said to merit this harsh punishment from the Surat court? Mr. Gandhi had said in a public rally, how come all thieves have Modi as the common son? Mind you, the BJP MLA Purnesh Modi had told the Surat court that by this utterance, Rahul Gandhi did not personally defame, but he had still filed the defamation case. Please note, Modi's surname is not used just by a few backward castes in Gujarat and Bihar, but by Jains at large, Muslims, Parsis, and a number of other communities. So there is no definitive caste, grouping, social or demographic cluster which could have been specifically insulted by Rahul Gandhi's utterances. It's a different matter that BJP made this out to be an insult of 13 crore OBCs using Modi as surname. How did BJP come to this figure of 13 crore? Is anybody's guess. On 20th of April, the additional sessions judge Robin Mugira in Surat, while hearing the maintainability of March 23rd judgment by the CJM, came out with another gem of an argument as to why the order of CJM should not be quashed. ASJ Mugira said the court was careful about not getting into the facts of Modi's surname remark, but looked into the prima facie evidence and observations of the trial court reflecting derogatory remark against Prime Minister Narendra Modi and further comparison of persons with Modi's surname with thieves, and complainant also having the same surname who is an ex-minister involved in public life. Thus the court refused to entertain the objections against maintainability of the complaint. In addition to this, ASJ Mugira used the same argument tended by CJM Varma to reprimand Rahul Gandhi. He said the court pointed out that Rahul Gandhi was not an ordinary person, but a sitting member of the parliament, and any word spoken by him has a large impact on the common public, and thus a high standard of morality is expected from a person like him. So you have two judgments from two courts now, which are virtually on the same line. Rahul Gandhi then approaches the High Court. In a 125-page order, the High Court noted that Rahul Gandhi took the name of Prime Minister to add sensation to his speech, with an apparent intent to affect the result of the elections of the candidate in favor of whom he was campaigning at the relevant point in time, and therefore the case would fall within the category of the seriousness of the offence, justifying the denial of benefits of a stay on his conviction. The High Court also said that the case also falls within the category of moral turpitude, as Mr. Gandhi, being a member of the parliament, possesses a high position in the society. In its order, the High Court made a categorical finding that if the conviction is not stayed, no injustice will be caused to Mr. Rahul Gandhi. In this regard, the court said that the criminal antecedents of the accused are a relevant consideration, and Gandhi has 10 criminal cases pending against his name. So this was again the third court which was virtually mouthing the same line of argument for punishing Rahul Gandhi. But it's a stay order on 4th of August. The Supreme Court threw out all these observations. A bench of Justice V.R. Gavai, P.S. Narasimha and P.V. Sanjay Kumar said that the trial court did not give any specific reason for imposing the maximum punishment of 2 years of imprisonment prescribed under the Indian Penal Code for the offence of defamation, though the offence is a non-cognizable one. I quote the Supreme Court order. Considering the aforesaid and particularly that no reason has been given by the trial judge for maximum sentence which has incurred disqualification, order of conviction needs to be stayed pendency of proceedings, which means that till the time the matter is finally settled with the courts, the order of the lower court, Surat court, is stayed. The order further states no specific reason has been granted by the trial judge to impose a maximum sentence from a comment by the court. Had the sentence been even a day lesser, the provision pertaining to disqualification would not have applied. Learned trial judge was at least expected to give reasons for imposing maximum sentence for the non-cognizable offence. Taking the High Court to task, the Supreme Court observed, though the learned appellate court and the High Court have spent voluminous pages in denying stay on conviction, these aspects have not been gone into. This clearly vindicates the stand of Rahul Gandhi in the court. And this also puts to perspective as to how within 24 hours Mr. Rahul Gandhi was disqualified from the Lok Sabha. No doubt the Congress camp is joyous, celebrating the stark stay order of the Supreme Court. The Bharatiya Janata Party, on the other hand, is holding on the fig leaf. Rahul Gandhi should be more careful in his utterances, a mild reminder to Rahul Gandhi about political propriety by the Supreme Court. But the larger question is, do we have a compromised, state-protected, or shall I say, state-reinforced judicial mindset, at least to the levels of High Court operating within the country? If this is so, we are in for a dangerous journey. While we have survived a committed and politicized bureaucracy, will we, the Indian democracy, survive a committed, politicized and polarized judiciary? If not, then are we not on the road to becoming another theocratic state in the garb of democracy, just like Turkey or Israel? These are all countries which are democracies today with absolute power to the ruling dispensation. The question is open. Thanks.